My first submission is that the Constitution of India bears the birthmarks of partition. And you cannot understand either the Constitution of India or the Citizenship Act without understanding what happened for almost a century before the partition occurred and what led up to this partition. And the birthmarks are there in the Constitution. Article 5 confines itself to the commencement, as has already been said. 6 and 7 deal with migration to and from Pakistan. And the Citizenship Act deals with acquisition of citizenship after the Constitution comes into force. My submission is going to be Section 6A is a sui generis provision. And that's why it's called special provision. So it cannot be slotted either into the Constitution or into Section 4 and 5. Possibly it can be slotted into Section 7 of Article 7, a proviso. Because my submission is the proviso to Article 7 leaves the door open for further migration and does not freeze the cutoff date at 19th March 1948. There's no freeze to migration, or there's no freeze to granting citizenship to people who enter India after 17th March 1948. And that is obvious from a reading of the proviso to Article 7. I'll make good that submission. Then, my lord, I'll address a few issues on Article 29. My lord, in my opinion, 29 has not been adequately addressed, and I'll attempt to do so. In fact, the Attorney General did not address 29 at all. I'm sorry, the Solicitor General made no submissions on Article 29. And my lord, from what I understood by the opening arguments of Mr. Divan, his major focus was on 29. And that major focus was confined to demographic changes. Nothing more, nothing less. It was not his case that the script, the language, or the culture of Assam has been impacted. If it was, I have not understood in what manner. And may I explain, my lord, I would like to invite your attention to certain provisions of the Constitution of India. Assamese continues to be in the schedule of official languages of India. Point number 1. Under the Constitution, adequately, completely protected. No question, my lord, of destruction of the language. Number 2, Assamese continues to be the official language of the state of Assam. Remember, my lord, at one time, Mr. Sibal informed you that Bengali was forcibly made the language of Assam. That was reversed. And Assamese continues to be the official language of the state of Assam. Therefore, my lord, there's complete protection of language script.
Bengali is also the official
Yes.
language of the state.
Yes.
And Bodo is also an official language.
Yes, my lord. I'm grateful for that information.
Assamese is the only.
My lord, I'm very grateful for that information because we are talking about a state which is bilingual. And therefore, my lord, what is the point of producing data to show the number of Assamese speaking people as against the number of Bengali speaking people in the state of Assam? It makes no sense. It's a bilingual state, a multilingual state. And as Mr. Sibal submitted, my lord, it is one of the most diverse states in the country because of the mass migrations that have taken place over the centuries, my lord, long before the Ahoms came to India, long before that. There has been migration into Assam. And this has led to the creation of a syncretic culture. No submissions were advanced on how the culture of Assam has been impacted. Now, my lord, a few more provisions of the Constitution of India need to be pointed out to see the special protection given to the state of Assam. The Parliament passes laws naming scheduled castes and scheduled tribes in different states. And my lord, I will share it with you because it's in the public domain. There is a law of Parliament in 1976 which gives you the names of the tribes who have been put in the presidential schedule. The intention being to protect their culture. These are constitutional provisions for protection of culture which are in place. And I presume it was his case that it was tribal culture which is being destroyed. One of the submissions made was self-governance is covered by Article 21. No attempt was made to justify that submission, but I'm giving you the answer If self-governance is a right, yes, it is protected insofar as Assam is concerned in relation to tribals under Article 244A. Tribal areas have been put in a separate schedule which gives them autonomy of administration. Now, my lord, these are the provisions which conserve customs. And if custom and culture are synonymous with each other, then their culture is protected. Please don't understand me to say custom and culture are synonymous. They are not. But nevertheless, assuming for a moment that culture and custom are synonymous, my lord, they are adequately protected by the Constitution of India, and no case has been made out for violation of rights under 29, which was the major argument addressed by the opening argument. 275. My lord, your lordship talked about development. Here is the answer to development.
Already there, it's grants from the union to certain states.
Mandatory grants for Assam, my lord, not for the rest of the country.
Yes.
Therefore, my lord, the brief submission that I'm making is that the Constitution adequately protects the right to culture of the residents of Assam. Now, my lord, I want to move to another issue. My learned friend used the expression throughout his arguments, indigenous people. Please note that the Constitution of India does not use the word indigenous anywhere. It uses tribes. I, for one, my lord, do not know who is an indigenous person of Assam. I don't know, because there is no legal definition of indigenous person in the Constitution of India. There is a definition of scheduled caste, scheduled tribes, and my lord, the rest of us who are citizens of India. So, my lord, kindly be a bit cautious about the use of the word indigenous. Instead, we can use the word tribes. The question then will be, is the culture of tribes endangered in any manner? And if so, by whom? So now, my lord, I would ask myself the question, how does one understand the word culture in Article 29? Freedom of movement and residence and settlement throughout the territory of India effectuate and comprise part of India's syncretic culture and unity. My lord, why do we have this freedom of movement across the country? In order to preserve our syncretic culture. We are allowed to go anywhere, do anything, and all our fundamental rights. Tomorrow I can migrate, but I don't know. Indian law does not recognize citizenship of a state. Let's be clear about that. We are citizens of India. And my lord, in answer to the question, why is ordinary residence so important? If you see Article 5 of the Constitution of India, it uses the word domicile. This is the significance of ordinary residence, permanent intention to permanently settle. My lord, even domicile is not a very well-defined concept. But taken from private international law, we know that domicile means the place where you reside with the intention of making it your home. That's the definition of domicile. And my lord, domicile, in fact, in this country has caused a lot of problems given the federal nature of the country. When it comes to things like admission to medical colleges, my lord, and states make reservations for people who are domiciled in their states, all those disputes have landed up in court. Whether any such preference can be given to domicile, and it remains, I think, an unresolved issue. But the reason I'm pointing to domicile is there are two running threads in the Constitution Part 2 and the Citizenship Act. One is the concept of permanent residence and intention to settle. And the other is persons of Indian origin. And here I would say Indian origin necessarily has to refer to undivided India, because Article 6 and 7 give them citizenship. So there's a running thread in the Constitution to give citizenship to persons of Indian origin. In fact, my lord, the demand, as your lordship knows now, is that NRIs and overseas citizens should be given citizenship, and the late Mr. L.N. Singh, we had agreed to this, after which we got the concept of long-term visas and overseas citizens, where the government now issues those cards. And currently, my lord, there are petitions pending before you, which talk about why we should not be allowed to have dual citizenship of different countries. Now, of course, I don't want to get into that issue. But what I want to emphasize, my lord, is that these are the two running threads. So 3 running threads. 1, the birthmark of partition. 2, the concept of giving citizenship to those who make their domicile in India. And 3, persons of Indian origin. Now, my lord, Article 6A satisfies all these 3 conditionalities. In principle, procedure, etc. is a different issue. But all these 3 conditionalities are satisfied by Article 6A.
Which are the 3 conditionalities?
As Section 6A of the Citizenship Act, my lord, and therefore its constitutionality must be viewed in that context.
Which are the 3 conditionalities?
One is the relevance of the birthmark of partition in this country. The second is the intention to reside permanently in India. And the third is a person of Indian origin, India being defined as undivided. These are the 3 guiding principles for determining the constitutional validity of 6A. Has Parliament gone beyond these principles?